Hi, let's talk about property division. And more specifically, let's talk about how you hold title on certain assets and debts. So often I'm talking to people who have a divorce looming and they'll tell me, oh, don't worry about us sharing this or that property. It's in my name only. Unfortunately, I have to break the news to you that title is not what determines whether or not you're going to share an asset or a debt. The number one most important thing that determines whether or not you have to share an asset or a debt upon divorce is the date of acquisition. So, for example, let's take a house. If you acquired a house during the marriage and it's in your name only, because you acquired it during the marriage, it's going to be community property, which means you must share it equally upon divorce. Let's talk about debt, a credit card. For example, let's say your wife has a credit card and only her name is on the credit card. And during the marriage, she charged things on that credit card and she bought things that maybe you didn't even know about or you've never even seen. Because she charged them during the marriage, it's going to be considered community debt and it must be shared equally on divorce. As with so many things in law and life, of course, there are gray areas to this rule. There's nuances, there's minor exceptions, but in general, the date of acquisition is really what determines whether or not something is yours and yours alone, or whether something is community property and you're going to have to share it upon divorce. The one way to change this rule is with a prenuptial agreement. Other than that, date of acquisition controls. To find out how this may apply to your specific situation, feel free to give us a call. We're happy to help.